expected that we would all agree, and one of the reasons they created a large republic really was to spread us out. But they did expect our leaders to be able to talk to one another. And so I'm very happy to join in this conversation today about an Article 5 convention. Professor Lessig has proposed that we go through it seriatim from the application process to the selection, to the rules, to the ratification. But of course, these 4 areas raise so many questions we couldn't possibly discuss them all in the time we have, certainly not in the 10 minutes allotted to each. So I want to break it down into 3 general areas as a way to approach it. First of all, I think we have to understand what the challenge in discussing the whole question is. And 2, I would like to suggest a framework as to how we approach that discussion. And 3, attempt briefly to apply that framework in the context of the 4 general areas that Professor Lessig has asked us to address. You know, the more you study the Constitutional Convention option, as it is generally called, although I think more appropriately called the Article 5 Convention, the more questions that arise, and certainly Professor Tribe has listed them in great detail when he testified before Congress some years ago. But you know, it wasn't so complicated for the framers, or at least it didn't appear to be if you read the Federalist and the few references that are made there in Federalist 43 and 85. You know, it was looked on by Madison in 43 that both sides, in a sense, the states and the federal government, can propose amendments. And in Federalist 85, I think there's a little language worth reading, because it makes it clear, as the text makes clear, I think, but not everyone believes the text sometimes, that it's mandatory on Congress. There shouldn't be an issue. As 85 says, nothing in this particular is left to the discretion of that body, meaning Congress. I think that's an important point when we look at an Article 5 convention. Congress's discretion is very limited, and one can question on each of the 4 points what discretion it really has. But when we look at just the first question of the application, it appears from the text that all the states have to do is apply. But in practice, most of the applications since the beginning have been rather specific. They've identified a particular area that the state wanted to address in a convention. So we have a series of questions. I'll just tick off some of them. Do the applications that are specific, do they count at all?